They said it couldn't be done. They said no one would dare. But in courtrooms across Alabama, a reckoning is underway. A legal war waged not for power, but for principle. Families are being torn apart. Parental rights dismissed. Due process ignored in the shadows of bureaucracy. But now the silence is breaking. A new wave of accountability is rising, and leading the charge is attorney Yancey Burnett of Spanish Fort, unshaken, unafraid, taking on the Department of Human Resources in a courtroom battle for justice. Armed with the power of Section 1983 civil rights law, he's exposing the system, challenging overreach, demanding constitutional protections be honored. This is the front line of a greater battle for liberty, for justice, for the future of every family caught in the crossfire. The fight is real, the stakes are high, and the system is finally on trial.
Hello, welcome to WFUZ-TV. I'm Blair Castro, and I'm here with Thomas Jenkins. Today, we're talking to Mr. Yancey Burnett of Burnett Law Firm in Spanish Fort, Alabama. Mr. Burnett, thank you so much for your time today. I would love to hear more about how you got involved with the case against Department of Human Resources here in Alabama. What first drew you into these issues? And tell us a little bit about the work you're doing here.
Yeah, it kind of starts, for me anyway, it starts with an interest in constitutional rights. So it's one of those things that most people don't quite understand about anything having to do with parents in general. They always think about it in terms of kids. Which is fine and appropriate, and we have to be concerned about the kids in those kind of environments and those kinds of cases. But the thing is that constitutional rights are supreme, and they're supposed to be supreme, and they're supposed to be paramount, but they're not always treated that way. And parents, in particular, parents' rights are not respected a lot of people call them DHR cases because DHR is involved, but really they're JU cases. JU is juvenile court. That's where those cases are handled. That's where they're tried, those sorts of things. And so in the end, it's about constitutional rights. So parents have a right to the care, custody, and control of their child. That's a constitutional right that's been around not for a little bit of time, but for more than 100 years, the right to care, custody, and control of your child. And so I've gotten involved in those matters for that reason, because I see those things being disrespected. I have part of my practice, a significant part of my practice, is bringing what are called 1983 actions, which is civil rights actions. And so we call them 1983 actions because the statute is 42 USC section 1983. And so a shorthand for them is 1983 actions, but it's a civil rights action. You're suing somebody who works for a governmental entity of some sort because they have violated your client's constitutional rights. And so even in the parental context, and most people think about that maybe in a police context, or they'll think about it in some other kind of context, but that statute applies to anybody who acts under color of state law. And so if you're a government employee, you're acting under color of state law, and you rob somebody of their constitutional rights, then you can get sued. And that's kind of the bottom line. That's the short answer anyway. It gets longer and more complex and more esoteric beyond that, but that's kind of where it starts for me. Yeah.
Okay, how did you meet Jimmy Fuson, and what brought you into his case? And since then, how has your caseload changed, and what is happening in terms of Baldwin County DHR specifically? Yeah,
in Jimmy's matter, he's got this JU case. And so I know we're supposed to call them DHR cases, but I don't want to call them DHR cases because that puts DHR in control, and they're not in control as far as I'm concerned. So they think they are, by the way. So in Jimmy's case, I mean, look, kind of the bottom line is his constitutional rights are at stake to care, custody, and control of his child. And so he has, DHR intruding into his life and pulling the kids away from him and pulling him away from his kids. And they do so in an obstructive way, and they do so without regard to his constitutional rights. So one of the things that DHR consistently does is they have no respect for the constitutional rights of the individual parent. They just don't. They don't care. They will always say, well, we're acting, because our paramount interest, they'll always say, are the interest of the child. which is fine in the sense that they have an obligation to protect the child, but they also have an obligation to the constitutional rights of the individual. So you have a social worker that doesn't know anything about the law and doesn't really care anything about the law. And what they're doing most often, is they're substituting their personal judgment into a case as opposed to respecting the constitutional rights and the judgment of the parent. And so parents get to make choices too. And so over and over and over again, they're substituting that judgment one for another. And so just because a parent makes one choice that you would not make, that doesn't mean, for instance, that they get to do that they have that right to substitute that judgment. So anyway, I can't get too much into the details of the weeds of Jimmy Fuson's case, but he in particular, I think, is kind of taking this on as a crusade, which one of the things I really love is when I have parents that I represent that really take it so seriously that they go learn stuff, that they aggressively pursue stuff. That tells me that I'm on the right side of this. In other words, they mean this. I mean, they care about their kids. They want so passionately to get their kids back. And I see that over and over and over again, that people will go a long way to help their kids, save their kids, get their kids back from DHR. And a lot of times the problem with all those parents is that they're trusting DHR to do the right thing. And you can't trust them to do the right thing because they refuse to do the right thing. You have to force them and compel them. This entire process is highly statutory. It is highly regulated. There are a lot of rules having to do with all this, and DHR ignores most of them regularly every day. So as a lawyer, you have to force them and compel them to obey their own rules and obey the law, and they don't do that. They're supposed to make best efforts, for instance, to reunite families. They don't do that. They often ignore families. They'll take away the kids, and then they will give somebody an hour of visitation. By the way, an hour of visitation for a parent is parental alienation under the law. That's alienation. In other words, you're trying to alienate the parent from the child. And so you have this thing that happens often where this intrusion comes in, and then they don't follow the law. And so I think for guys like Jimmy Fuson, he just wants everything that everybody else wants. He wants his kid. He wants care, custody, and control of his kid. He wants his rights enforced. And so that's what we endeavor to do, to follow out that process to make sure it's done. After we win these cases, sometimes we can file a 1983 action, a civil rights action against DHR, because they often do these things inappropriately, wrongly. They have to have a certain legal basis in order to bring these cases and claims, but they often just don't. They just kind of substitute their judgment. And I hate to say it, but I can give you example after example after example. And a lot of those people, by the way, have come into contact with Jimmy, and then he'll kind of redirect him to somebody who can do something about it, which is me. So, and we can, and we often do, and we succeed in a lot of these cases. And I think a lot of it just has to do with awareness of the statutory scheme and a refusal to be bullied and pushed around by DHR. Because believe it or not, they try to bully and push me around too. Can't do it. Refuse to accept it. But they bully and push around parents all the time. And I think they just get it in their head that they get to do that to everybody. You have to refuse to allow it.
One thing I noticed with Jimmy's case was he was able to show through his paperwork that DHR is constantly moving the goalpost on him. Changing what hoops he needs to jump through in order to get Billyana back. Have you've seen that with his case and with other cases as well?
We see that on a regular basis, and so all of which suggest to me that maybe they have another purpose in mind. And so we'll get to that in a minute, maybe, but yeah, they do. So they'll start out saying, okay, we just need to make sure that if it's somebody with a drug problem, for instance, they'll just say, oh, we just need to make sure you're clean. And so then the person will be clean for 6 months. And I say, okay, well, we need longer than that. And then it's 9 months. And then, okay, well, we need longer than that. And then it's a year. And so then it's, okay, well, we need to get an evaluation. We need some therapy. We need some counseling. And so you have parents that are always willing to go the extra mile. Parents love their kids, sure. and they're willing to go the extra mile to do all this stuff. And for the parents, I really don't have any clients that just say, to heck with it, I don't care. Because they aren't going to hire me, right. They aren't looking for me. They aren't seeking me out and finding me. The parents that care do. they seek me out, they find me, and they want to fight for their kids. So when parents are put in a position that they had, sometimes they just had some negative event happen. It might have been somebody who's a victim of domestic violence, but they're in the home. And so DHR comes in and says, well, there's domestic violence in your home. And so we're going to remove the kids, and we need to make sure that you get some therapy or some counseling or this or that. Sometimes it's a drug problem. You need to make sure you're clean. And the kids are never exposed to that. But then they will often change all the rules over and over and over again. And then, so look, in all DHR, in all of these cases that involve DHR and these JU cases, you got to keep in mind that they're the big five. There are big five things that always end up having kids removed from a home. And it's abuse, neglect, drugs, alcohol, and crazy. And so those are the big five. It's always the same: abuse, neglect, drugs, alcohol, and crazy.
Is there a statutory cap on when have you been sober long enough to get a child back? Is there any statute for that, or is that just the court calling as they see it, as they see fit?
I mean, really, it kind of comes down to the judgment of the judge. Mm-hmm. And so one of the things that often happens in these cases, and sadly, I don't think a lot of lawyers really know this that are representing, especially court-appointed lawyers that represent some of these people, they don't know that they can force the issue when somebody's clean. So I was just in court not too long ago for somebody who had been clean for 2 years. And of course, I'm saying to the judge, no, we gotta determine dependency today. And so there are ways to force that issue. And so because this is what matters, is that dependency is the most important legal issue in all of these cases. And so dependency basically comes down to the fitness of the parent. And if the parent is not fit, then that means the child is dependent upon the state as opposed to being able to be taken care of by the parent. So dependency, when it's defined though, so you have what's called a 72-hour hearing, which is literally within 72 hours. So if a kid is taken for some reason, whatever the reason is, drugs, alcohol, any of those five things. So usually it's going to be abuse, neglect, drugs, or alcohol. So if it's taken for any of those reasons, then you have the 72-hour hearing. That's not a dependency hearing. The dependency hearing is the next important hearing that you have. And so that determines dependency. And once dependency is determined, there are other times down the chain when you can have that dependency finding. And that is, I think, the failure in the system, is that over and over and over again, because of kind of the way juvenile courts are run. And so I don't think there are all that many lawyers like me, but for the few lawyers that are like me, that'll kind of buck the system and intrude into that system, we won't allow the goalpost to be moved. And beyond that, we compel a finding of dependency. And this is the thing about dependency, is it has to be on that occasion. And so when you're talking about the time spans, like you were just asking about, and so you got somebody that's maybe 2 years clean, that when the court has a finding of dependency at the 2-year point, you got to find whether that child is still dependent at that time. It is about that time. In other words, they can't just, and this is what often happens. They will often, and I see lawyers do this over and over and over again, they will just adopt the previous dependency evaluation from a year ago or 6 months ago or a year and a half ago. And they will say, that, okay, well, that's already been found by the court. So they'll take it as this has already been found by the court. So we will just take that as if it occurred today and move forward.
People can't change.
And move forward to the next hearing. But what they fail to understand, now as a legal concept, that's been around for a long time. Like once a court decides something, that it's decided and you don't challenge it. But this is not that. This is not that kind of situation. Right. This is a different kind of situation. And the law that way too many lawyers in this situation don't understand is that dependency is defined more than once during the course of this entire process. From the beginning all the way to the end, there are multiple times when it can be determined, and you, as the party, can force it to be determined. In other words, when I think my client is ready to go, that I can win that in front of a judge, when they're clean for, say, 2 years or 18 months, even, or sometimes less than that, depends on how bad the event is.
Sure.
Then you can file a motion, you can get in front of the judge, and then you have to teach the judge, because most judges don't know that the law allows and case law says, in other words, the Court of Appeals has said specifically in case law that we can force that issue and force another determination of dependency at that time. And that's the important thing, at that time. So in other words, what they'll always try to do is they'll say, well, the child is dependent because of what happened 2 years ago, because there was a bad event 2 years ago. There was an incident 2 years ago. There was a drug problem 2 years ago, or somebody got caught smoking dope 2 years ago, or somebody, whatever it is, whatever the thing is. And sometimes, by the way, it has little or nothing to do with my client. Sometimes it has to do with somebody else who was in the home but is no longer in the home, or they've been removed from the home. That's often the case. And so you have these people that are innocent, or they have made themselves innocent because they have cleaned themselves up. And so, so there's no specific rule that says, hey, you got to be clean for a year. But I've seen Court of Appeals cases where they reverse termination of parental rights cases after 9 months of being clean.
Mm-hmm. So that becomes dangerous because from my understanding with talking to Jimmy, after a year, a child is eligible to be up for adoption for the foster care family. And so does that not create a dangerous pathway for somebody losing their kid permanently?
Sure.
Through the lack of due process in a timely manner?
Sure. And so what often happens, that DHR makes choices that extend those goalposts, like you were mentioning before. And so if you extend out the goalposts long enough, so in other words, you keep changing the rules. So you tell somebody, you got to get clean, and then they're clean for a year. And then after a year, they say, we got to get you evaluated. We got to get a psych eval of you. And not only that, we want you to go to some therapy and counseling. So the easiest thing to do, and this is how they extend the goalpost. So they'll say, all right, you got to be clean. And then you're clean for a year. And they say, okay, well, you're clean for a year, but we got to get a psych eval. And then when they get a psych evaluation, then the psych eval comes back. And then they say, okay, well, the psych eval comes back and they've recommended that you do therapy. So now we'll do therapy and counseling and stuff like that. And so then you got to do that for a while. How long are you going to do it? Well, as long as they say. So that's another 6 months or a year. And so now they've extended it out 1 year, and now they extend it out another year by doing this kind of stuff all the time. You have that they're limiting you in your visitation with your child for maybe an hour a week, which is disgusting. I got a child. I can't imagine seeing her an hour a week. You're kidding me? That's all I get with her. And even if she was not in my home, an hour a week. I mean, we don't do this to the worst, child abusers in DR courts, in domestic relations courts. But somehow here, it seems like, and these people are supposed to be taking care of kids, but this is specific parental alienation. In other words, they are trying to alienate the parent from the child. And so they limit you to an hour. And when they limit you to an hour, that harms the relationship. Then they'll claim that, well, the parent-child bond, it's broken. Well, that's because they went out of their way to try to break it. And then you've got this time, they move the goalpost to try to extend out the time. And so all of which makes me think that their interests are not what they say their interests are. So their statutory interests, in other words, what the statutes require that they do, is they're supposed to reunify. They have an obligation. An affirmative statutory legal obligation to reunify. But they don't do it. So the statutory requirement that they reunify, they ignore completely. They don't try to reunify. They just focus on what that person has done wrong and say, you got to get clean, got to get some therapy. And they don't try to reunify at all. If they were trying to reunify, what would you do with visitation? If you did start at an hour, then you'd increase it to 2. And then you'd increase it to 3. And then you'd say it goes from supervised to unsupervised. But they're going to have supervised 1 hour. And they've got... there's some people that, I get a lot of people that were represented by court-appointed lawyers, and then they come hire me. And I got a lot of people that are 2 years in when I get them as a client, and they're still at 1 hour. In other words, you people aren't trying to reunify. If you're 2 years down the road and you got 1 stinking hour of time of visitation, you're not trying to reunify. And so I don't care how much they say, oh yeah, we're trying to reunify. Liar. You're not. Not if you're doing 1 hour 2 years after the fact, when the client has been clean for 2 years. You're just lying to me. It's just a fraud. And so I think that they have different interests in mind. And so I don't know how much you want to go down that road, but
I definitely wanted to ask about the psychological assessments.
Okay.
You briefly touched on that, but from our understanding and the research we've now done on it, there's a lot of questions as to the validity of the psychological assessments, as to who really needs them, where they're going, the selection of the professionals. I'd love for you to talk a little bit about that, because it seems as though that is really the crux of a lot of the issues for a lot of people. They dwindle down to these specific physicians or doctors and their assessments. So how often do you see these assessments really holding, how much weight do they hold, and where's the dangers with that?
Well, first of all, DHR chooses who they go to. Secondly, DHR will never choose who you go to unless they know that evaluator, generally a psychologist, generally a clinical psychologist, is going to give them the opinion that they want. So, in other words, they're not looking for an honest assessment. They're not looking for that at all. They're completely fraudulent and mercenary being the kindest term that I can use, in how they go about that. So they're going to choose somebody who's basically willing to prostitute their psych license in order to give them an opinion. Now, look, they can do that because they're going to act as an expert for DHR. Then they get paid from DHR. That's how they make their money. And in that case, I can be very specific about some doctors that they use. I can tell you exactly who they want to use. It's the doctor they've been using for a good long time, all over the state of Alabama, by the way, not just in Mobile, not just in Baldwin counties, not just in southern Alabama. The doctor's based in Mobile, but he does psych evaluations for people all over the state. I've been up in Huntsville, I've been in St. Clair County, I've been in Shelby County, I've been all over the state doing these cases. And Dr. Carney is used over and over and over again for psych evaluations because he has a willingness to do and say whatever they want in order to give them a ridiculous opinion on my client. And so, now how do I know that? Well, I'll tell you how I know that, because a couple of different reasons. So first of all, they send him to him for a particular reason. There are a couple of things about his opinions that are always consistent. And so one is that he always makes predictive opinions. And so he has these wild evaluations that include this predictive behavior. Well, in the state of Alabama, the Court of Appeals has said that predictive behavior. So in other words, this is what I mean by predictive behavior. He's predicting in the future about what a parent will or won't do. And so predictive opinions by a doctor, or for that matter, by anybody, it's not even evidence in the state of Alabama, and the law says so. So in other words, there's Court of Appeals law that specifically says, in regard to Carney, by the way, in other words, I'm not talking about a case that says that predictive behavior, when analyzed by somebody else, is wrong. Specifically in regard to Jack Carney, the Court of Appeals has held there's a case out of Jefferson County that went to the Court of Appeals that ruled on this specific question. And the Court of Appeals said that predictive behavior is not worthwhile, and it is sheer speculation, and it's not even evidence. Not only is it not evidence, it's not evidence that could reach the standard that you have to reach in these kinds of cases. In these kinds of cases, you got to have clear and convincing evidence of dependency. Clear and convincing. Clear and convincing is just below beyond a reasonable doubt. Beyond a reasonable doubt for a criminal case. So think about that. And so when I talk about predictive behavior, this is the kind of thing I'm talking about. So what he consistently does in these cases is he will say, so for instance, he's got a woman who he's evaluated, and he'll say, she won't act to protect the child from somebody else. Like if there's a person who is maybe at issue who's using drugs or alcohol or abuse or whatever it is, I predict that she won't do that for whatever reason. She'll, whatever he says, zone out or not pay attention or not have the wherewithal to say, no, stop that or whatever. So you have this kind of ridiculous predictive behavior, and what the Court of Appeals has said is, first of all, the predictive behavior is sheer speculation. It's all not evidence. And the second thing that the Court of Appeals has said is that what matters is what people do. So I have clients, for instance, that have acted to protect a kid, but then you've got Carney that's saying, I predict that she won't. but wait a minute, her actual behavior is protecting the kid, but you're predicting somehow over reality. You know, in other words, ignoring reality, ignoring what has occurred. I got clients that have called the police, that have acted to protect the kids, that have, gotten the kids away from the person who is not sober or something like that. In other words, done all the right things that any reasonable, rational person would do to protect the kid. And what is he saying? He is saying, well, ignore reality, I'm predicting this. Now, why is he doing that? He's doing that because he's paid to do that. And so the other thing about those opinions, and Dr. Carney in particular, and just so you know, I have some litigation against him, and we've got somewhere around 50 people that are going to be part of that litigation to file suit against Dr. Carney. And that number seems to keep growing because he's been all over the state, and he's been very active for a good long time. And so I know a lot about him. And so the other thing that I'll tell you about him is that he does what that court that I was referring to before referred to as a battery of psychological tests. So he has a couple of standard tests that he does. And so one of those tests is called an ITAT test. It is a test from the 1930s. It is widely discredited, and there's absolutely no studies whatsoever that suggest that it has any predictive value at all. None. Zero. So not a single study that supports him using it as some sort of predictor of behavior, and in particular predictive behavior in regard to substance abuse or something like that. So he often predicts that somebody's going to go back to using drugs. He predicts that people won't protect others. He predicts that they're going to act in a negative way, that they don't have control of their anger. So he makes all these kinds of predictions, ridiculous stuff, and sometimes crazy kind of predictions that are unbelievable, kind of on their face sometimes. But he has a willingness to say pretty much anything. And why? Because he's accustomed to the idea that he will never, ever, ever be held responsible, which is exactly what we're trying to do. And so the other thing he does is he kind of misrepresents to people what his actual role is. So he's hired and paid by DHR to be an expert. And to give them, which is why I call it mercenary, to give them the opinion that they seek. And so when they want to do that, they can hire them, they can do that. And of course they have a list of approved people. And so what DHR will always say to somebody is they'll say, all right, we want you to go to get a psych eval, we're going to send you to Dr. Carney, and you've got to go to Dr. Carney. And if you say, well, I don't want to go to Dr. Carney, I've heard bad things about him, then they'll say, well, we're not going to accept anything other than you going to Dr. Carney. That's all we're going to accept. And people get intimidated and bullied by that. So if you're a lawyer on the other side of that, then your answer has to be, don't care, I'll find somebody else on the list and we'll send them to that person. Mm-hmm. And there are other people that are approved that will give you just an honest, straight up opinion. And if DHR walks into court and they say, Judge, we don't want to accept this because we didn't approve of this, we didn't send them to that doctor, they have to pay for it themselves, that's the other thing, is that they won't pay for it if you go to somebody else. Then, you have to just not care what DHR says, because really it's not about what DHR says, it's about what the judge says. So if the judge rules, DHR can whine and complain, and they can say, well, we don't like that person. Well, the person we went to was on your list. So cry me a river. I know why you wanted me to go to Carney, because he's willing to say whatever you want him to say, but we wanted to get a real opinion, not a fraudulent opinion. So I went through one of the tests, the ITAT test, but one of the other tests he does is called the Milan test. That requires a pre-existing diagnosis of a personality disorder. A pre-existing diagnosis, that's a big deal. So I in all the clients that I have, and I don't know, I got more than 100, of these kinds of cases. I have, I think, maybe 2 clients that have a pre-existing diagnosis of all 100 people that have had a Carney test. So I got 100 people that have had a test with Carney and have had the Milan test, and I got like 2 that fit the criteria of having a pre-existing personality diagnosis. Think about that. So this is what happens if you administer the test without the pre-existing existing condition. So you administer the Milan test, and it's Milan. It's not spelled like the city. It's Millon. So, And so, sorry about that. And so the Milan test, though, it is administered only if you have that pre-existing condition. And the Milan test, if you administer it and you don't have that pre-existing condition, then you will over-pathologize anybody that takes the test. So anybody, and over-pathologize is just a fancy way of saying you're going to overdiagnose whoever takes the test. So if I administer a test to you and you've never had any pre-existing personality disorder diagnosis before, and any personality disorder, so it could be borderline personality disorder, it could be narcissism. I mean, there are a bunch of different diagnoses that are possible. But if you've never had any kind of personality disorder diagnosis and you take that test, the test will end up showing that you're all kinds of things that you aren't because you don't have that pre-existing in other words, but he does that over and over and over again. He does that repeatedly. So, like I said, I got, more than 100 people. I got like 2 that have a pre-existing diagnosis, but he's given at least 100 of my clients these tests. And so it's crazy to me. So in other words, he doesn't really care what the rules are. He doesn't really care. All he wants to do is give the appearance of being a psychologist. And the other thing is that he doesn't even have, he has a PhD, but he has a PhD not in clinical psychology. He has a PhD in the philosophy of psychology, whatever that is. So he doesn't even have a PhD in clinical psychology. He should be a clinical psychologist to do what he's doing, but he's not. And he should have some sort of specialty or subspecialty in regard to children or development or families or family units or family therapy or family counseling or any of those kinds of things. He has none of that. By the way, his background is in PTSD and veterans. But he makes a whole lot of money. Last full year, he made $237,000 from DHR that we know about, that the state admits. But we also know that he got a lot of payments that are cash, that are separate and apart, not counted in that. And we also know that he was doing the same thing with Social Security, and we don't know yet the numbers on how much he got paid from Social Security. And we also know that he was, at the same time that he's getting paid from DHR, he's also billing my clients their Blue Cross Blue Shield and billing their United Healthcare. So he's billing their private health insurance and getting paid by them at the same time that he's getting paid by DHR. So he's double billing a lot of stuff. So he's making a fortune. So I know why he's doing it. He is making a whole lot of money from doing this. And I get why DHR does it because they're very mercenary about it. They just want the opinion that they want, and they know that he will say horrible things about the person they want horrible things said about. So the next question becomes, or the question inevitably becomes, is why would DHR do such a thing? Anyway, so.
For me, the question is what happens next in terms of stopping him? Why has he been allowed to do this for so many years?
Because nobody has gone against him and nobody has challenged DHR and nobody wants to challenge the system. And I don't know, I'm just that guy. So
what is the fear?
And so, well, it's that that you might, that if you challenge DHR, then DHR might take some retribution against you or your clients or something like that. I am absolutely not bothered by DHR doing any of that because I don't believe that they have nearly as much power as they think they do. Because I view the judge as being the powerful force. And some of the judges absolutely get bowled over by DHR, but I think a lot of that is because the judges don't know the law and they don't understand it and they get stuck doing it. For whatever reason, they end up getting assigned to do JU stuff. And then they just kind of think this is how it all works. And most of what is in front of most of these judges is a whole lot of agreement, actually, because you got to understand how these JU courts work. They don't work like your normal criminal court where you've got, 15 or 20 lawyers that are all representing all kinds of different people, and you've got some appointed but some retained, and you've got a judge, that's kind of running the courtroom and going through his docket, and you got a bunch of criminal defendants in there and a bunch of witnesses, and everybody's in the same courtroom, and you got like 100 people that are all in the same courtroom, and they're all packed in, and you just churn through the docket, and judges most of the time try to get the easy stuff done, and then whatever's more complicated like hearings and trials and stuff like that gets pushed toward the end, which is kind of standard for most judges. But that's not how JU court works. That's not how it works at all. You got the judge, of course, at the center of everything. Then you got DHR, and you got a GAL, and you've got court-appointed lawyers, and all of those people are all getting paid by the same people.
So it's just a huge team of a legal team against you from the start.
Yeah, and so and all those people get their paycheck from the same people. And so the court-appointed lawyers, even for the people that I end up representing, for the moms and dads, so they got court-appointed lawyers, but those same court-appointed lawyers are there all the time. And so there ends up being kind of an insular, I think it's insular and it's incestuous. And so when I come into that courtroom, I'm intruding into their world and I'm kind of upsetting, the norms.
Sure.
And so I come in, and then the person who would ordinarily be representing my mom or dad, he's got to sit down and he's not part of it anymore. And I am, and I'm representing them. And I'm the guy that's not agreeing with DHR, and I'm the guy that is upsetting their insular, incestuous apple cart, so to speak. And so they're, of course, unhappy with that and bothered by that. But it's also necessary in order to appropriately represent your clients, and if you're going to be appropriate about that. And so to understand, though, all those people that I talked about before that are maybe in a criminal court are not there at all. Because you got to understand, juvenile stuff is all private because it involves kids and young people and all kinds of private issues having to do with those people. So the courtroom is empty except for those people that I named, and all of them get a paycheck from the same place. The judge gets paid by the state, DHR gets paid by the state, the supervisor for so the DHR lawyer gets paid by the state, the DHR caseworker gets paid by the state, the supervisor of that DHR caseworker gets paid by the state, the GAL gets paid by the state, the appointed lawyers get paid by the state, everybody gets paid by the state except for me.
Who does the oversight to make sure that the system runs correctly without having to get lawyers involved? Usually when it's running correctly.
Yeah, I mean, really, for the most part, it's about everybody is supposed to act according to, for lawyers, you got ethics rules that govern what you're supposed to do. You're supposed to take care of the interest of your client. But what happens, and this is the reason why I refer to it as incestuous, is that everybody kind of thinks of themselves as, we're kind of on the same team and we want to move the docket and we want to move things along. And so you've got a lot of people and so then they'll say, okay, so who's next? Smith is next. And so, the Smith people come in, and then they've already got a deal worked out. And so the Smith people are walking in, the appointed lawyers are telling them, this is the deal we've got walked in. We're going to go in front of the judge and he's going to okay the deal, and then we're going to move on. And so, they're going to say something like, well, we got a permanency hearing set today, and so we've agreed to stipulate that we're not going to have a permanency hearing today. We're just going to stipulate that to move along, and we're going to, of course, stipulate as part of that we're going to argue, later on down the road that we oppose, what they're trying to do with permanency. But that's the agreement. And so that's what we're going to do. And so then they kind of feel comforted by the fact that we're agreeing to argue about it at the next hearing, at the next maybe adjudicatory hearing, or at the next occasion, or maybe when there's termination of parental rights, we'll argue about it then and we'll oppose everything. But that's what they're being told. Mm-hmm. But what they're not fully being told is that you could, at that time, in that context, go to war over dependency there. And if they knew that, if they fully knew and understood that, then they'd be saying, what the heck is my lawyer doing agreeing to all this stuff? In other words, you have all these agreements that are made, but people don't fully understand what they're agreeing to.
Yeah.
And so you have these events that happen over and over and over again where you say, okay, have the Smiths come in. And the Smiths don't know what the heck's going on, and they don't understand the law. And all they know is, they want their kids back.
Right.
And that's all they know, man. They just know they want their kids back.
Would it be possible to doge the DHR?
Oh, well, I mean,
in Congress or the House, just clean up the place if it's such a systemic failure that's so widespread, it seems like it would need to be gutted and maybe rethought.
I'd say it absolutely needs to be rethought. And one of the things that I know they've had issues with in the past, I mean, I don't get to litigate a lot of those things, but I know that they have charge of and handle a whole lot of money that has to do with child support and stuff like that. So, and they deal with a lot of those things, and they've had some issues with how they handle that money and whatnot, highly questionable. The problem with all that is that you don't have a lot of parties that have access to that information. Mm-hmm. And so that's why litigating it is tough. Because of what I litigate, so kind of think of DHR split into two parts. So half of what they do is child support stuff. and half of what they do is kind of the dependency issues that we've been talking about. And so the part that I deal with, kind of gets to the perverse incentives. And so I think they've got two very awful perverse incentives. And so the perverse incentives that they have, which are financial in nature, are, that there's a federal statute called Title IV, it's Roman numeral 4. And so Title IV funding feeds DHR in two different ways. It feeds them to get, if they snatch a kid, keep the kid for a while, then adopt the kid out the back door to somebody else through a foster family or in another way, they will receive $1.25 million under Title IV funding, Title IV-E. And so, second thing is if they snatch a kid, and yeah, you could put a kid with the family's other family members, like a grandparent or a mom, dad, uncle, whatever. But of course, they always choose not to do that. Why do they do that? Why do they stick them with a foster family instead? And the reason is because Title IV funding pays them to stick them with the foster family, but they don't get paid if they stick it with, somebody's uncle or friend or something like that. So, I mean, these are all evil decisions driven by money. And when I call it a perverse incentive, it's because, of course, that wasn't the original intention to encourage this kind of stuff. And you require, which is kind of getting back to one of the questions that you asked before about, the intentions of the people involved. They would probably say that, well, I'm just doing the best I can for my client, and I've got a bunch of appointed people and whatever. But there aren't enough people involved that want to push things to be done the right way. And DHR has zero interest in it being done the right way. They just want their financial incentives carried out. And they have no interest in doing right, by the kids. And by the way, when you get caseworkers that have, some inclination of doing things in the right way, they get run out of the place, because they got bosses that run them out of the job. And so yeah, in other words, it requires some ethics. It requires some ethics. You got to have a lawyer that really cares about his client and does whatever he's supposed to do to represent his client appropriately. And that's not always done. You have way too much agreement by the appointed lawyers, and some of them do, an okay job. Some of them do all right and do fine. But for the most part, I'm kind of generalizing. So I'm sure there's some that try very hard. But for the most part, there are way too many appointed lawyers that just don't do their job. And that's just because I'm kind of a believer that human beings are lazy for the most part. And so human beings tend to act in a lazy way, and it's just the easiest thing to do. The easiest thing to do is to agree. The easiest thing to do is say, okie dokie, like the example I gave you before. And the reason I give you that example is because it just happened to me not too long ago. And I had a permanency hearing set, and I walk in, and what does the DHR lawyer say to me? The DHR lawyer says what all DHR lawyers says. Hey, Yancey, most of the time, you know what we all do? We all just stipulate to move this down the road, and you can stipulate, of course, that you will oppose, our permanency goals and all that kind of stuff. And so what I do, I said, I understand that's usually what's done, but I'm not going to do it. So, and of course, what does she do? She comes back again and says, Yancey, you understand that this is not the way we usually handle these things, right? And of course, what she wants me to do is she wants me to stipulate, agree, so that we can just move on. Instead, we end up having, a kind of a quasi-hearing and an argument over the law about what a permanency hearing is and what should be required. And then the judge ends up changing the permanency goals from adoption to reunification. And so that's what I wanted. I want the goals changed. I'm never going to agree to your goals. And so I know what she wants. She wants me to go along with the goals of adopting the kid out the back door so she can get her $1.25 million. And I know exactly what she will try to do in the future because she's a DHR lawyer. She's desperately going to try to cut off my parent and try to get that kid adopted, out somewhere else. So she'll try again later to change the goals. And why is she going to do that? Because, she wants her $1.25 million for DHR. That's why. And she doesn't give a rat's about the kid. So DHR always pretends to care about the kid, but they don't care about the kid. If they cared about the kid, they would want the kid back with the parents that are clean. In that case, I got two parents that are clean for 2 straight years. 2 straight years they've been clean. And of course, the judge is asking the same thing any reasonable person would ask. How long do they have to be clean before you think they're clean?
That is the question.
Because the judge was saying to them, It's 2 years. And I'll tell you why. You know what the answer was? The answer is they got evaluated by Carney and it was bad. And in that case, thankfully, had a pretty smart judge. And even the judge was saying, yeah, but I've seen some of Carney's opinions and, they're, somewhat
And that's how
questionable.
well known that is.
Oh,
And
yeah.
it's still in place, and that's the shocking thing.
Oh, I think anybody involved in the system, even the DHR people know he's a whore. I mean, he's in which I know sounds harsh, but he is prostituting his license to do what he's doing.
Mm-hmm.
And so I know what he is. Everybody knows what he is. DHR knows what he is. They know exactly what they're doing when they send somebody to him. They send somebody to him because they know he will say anything.
And not even qualified to write a prescription.
And so I've got bukus of evidence that no, he can't write any prescriptions. He's not a psychiatrist, and he's barely a psychologist. But anyway, he is that, I guess. But he's certainly not qualified to do what he's doing, at least in my opinion. And beyond that, I've got bukus of evidence of a lot of people that, he doesn't do any of the normal things that a psychologist is supposed to do. And he often misrepresents what he does. He always says, for instance, that he interviews people. That's not true. He doesn't. None of these people have been interviewed. He'll talk to them for maybe 5 or 10 minutes, but he doesn't do an interview with them. He gives them a list of questions and he has them answer questions. So when he tells people, and he tells courts, he testifies under oath regularly that he is interviewing people, it's a lie. He's not interviewing these people. He just doesn't do it. He has also lied to Social Security about interviewing people, and he charges them for that, false charges that are made to them. So he's billing people for things that he's not doing. He is claiming that he's interviewing people when he's not interviewing people, but DHR doesn't care. DHR knows how mercenary he is in his behavior and conduct, but they're being mercenary in their behavior and conduct too. They know what they want. They want the fraudulent opinion because they don't care about it being true. They just don't care. So anyway, I mean, as far as what we're doing in regard to Carney, so we're actually having a town hall pretty soon on this topic, and so
When and where will that be?
we don't have a date set for it yet, but it's going to be in the next 2 weeks,
Okay.
and it's going to be at Daphne Civic Center, which is down on 98
Okay.
in Daphne. We're just trying to make it in an easy place that people can get to. We're going to schedule it on a Saturday afternoon so that people can drive. For those people that need to drive like an hour or two, that can get there and be there at 2 PM and be able to get back at a reasonable hour. So a couple of different things that we'll do in that. So part of that is undoing and attacking every single judgment that resulted from any of his opinions. And so we're kind of going to divide people into groups. There are going to be some people that have a 1983 action, a civil rights action, and there are going to be some people that we're going to sue Jack Carney directly for basically what is malpractice, essentially. In the alternative, we're also going to sue him for fraud, because he fraudulently conceals who and what he is. And that also has to do to a great degree with the billing and the fraudulent billing that he does, where he double bills for these things. You can't both. See, anytime a doctor or a psychologist or anybody bills a health insurance company, they're saying that they're a treating physician. Mm-hmm. But at the same time, he's an expert. Can't be both things. You cannot be both of these things. And so you can't be a treating physician and an expert. You got to pick one. Mm. And so what he's doing is he's playing both. And so he's, to DHR, I'm an expert. To them, I'm treating physician. But then he violates HIPAA, which is another thing we'll be suing him for, because he won't give anybody their reports. Now, why does he do that? Because DHR didn't want it, which, by the way, is also a violation by DHR. So DHR orders it up, requires that you go somewhere, won't give you your report. And so over and over and over again, I got so many clients that have been refused reports from people, and which is crazy to me. And so bottom line is we're going to start filing a suit over this stuff. I'm not putting up with this. I'm not going to allow my clients to be bullied by this. You're going to tell me I got to go get a psychological evaluation, but you won't give me the report. And not only that, you're going to make me pay for it on my insurance, and you're going to have an expert payment made to him too. So he gets paid twice for this. So he gets bukus of money, and then you won't let me even have the report. This is bullying. It's garbage. Not only that, all of that is true, but it's also illegal. I mean, it violates HIPAA, and it's fraudulent concealment. I mean, this is disgusting stuff. So, I mean, it's I mean, to me anyway, it is offensive. And so as a lawyer, I see this stuff and I see my clients being bullied, and I see a lot of people being bullied that, they may not be, sufficiently sophisticated to even know that they're being bullied. They just know there's something wrong with this. There's something unfair about me having to go do a psych eval, but I don't even get the report. How can that be right? So they know there's something wrong with it, but they don't know exactly, what's wrong with it. And they don't necessarily know all the time that there's been double billing going on. Because a lot of my clients are saying, oh yeah, he billed my Blue Cross. He billed my insurance. And they don't know that there's something wrong with that. They thought that was normal. And of course, I have to explain to them why that's inappropriate. I said, of course that's wrong. He's lying to you. This is a fraud. This is a fraudster here. You can't be both. You can't be both. You can't be both the expert and the treating physician. If he's a treating physician, then he has a different role and different obligation. But in order to make the insurance claim to Blue Cross or United Healthcare or whoever you're billing Medicaid to, by the way, you have to claim that you're a treating physician.
Yeah, something really noticeable that we've seen now since researching this is so much fear, and many people are reaching out anonymously or just too afraid to speak up about this. And anytime you take on a government entity or you want to stand up to the usual system, I know people tend to be afraid. So kind of a personal question, what drives you to not be afraid? What gives you sort of this empowerment to speak up anyways and sort of push any fears aside? Because even us just researching this and doing a story on it, we've got so many people saying, be careful, watch what you say, make sure you don't quote this, make sure you don't say this. People are very scared.
Yeah, I understand that, and a lot of people are scared, and so I've had a lot of people talk to me about that. I don't know if I can talk to you about this, Yancey, because, and they'll tell me that, and so first of all, to answer it in regard to me personally, it's pretty simple. In addition to being a lawyer, I'm a minister, and Jesus Christ is my Lord and Savior. I believe it in my heart, confess it with my mouth, and if God is with me, then who can be against me? That's out of the Bible. So as far as I'm concerned, this is my godly purpose. I'm supposed to fight for these families and fight for these parents. I'm supposed to help them. And so I just know Deuteronomy 20 verse 4, which says, he is the Lord my God who goes with me to fight for me against my enemies, to bring me victory. And so my favorite verse, Deuteronomy 20 verse 4. So anyway, that may be more Jesus than you wanted to hear today. But look, so that's how I kind of view it. And so if he wants to come at me, and by the way, I know that I know that there's a lot of fear in some of these people, and they're scared that what DHR is going to do. And by the way, they threaten a lot of this stuff. DHR does. And so the problem that they create when they do this in regard to my clients is that I turn that into a civil rights case and I bring it against them and I make them pay for that. So the threats that they make to my clients when they try to bully and intimidate and manipulate, I'll give you a quick and easy example. So, because they think that they can do anything. So I have a young lady that has now aged out of the system, and her mother, and I represent them both. We filed a civil rights case over this. So this is pending in federal court right now. And so in that matter, what they did when that young lady before she aged out, when she was 16, 17 years old, was they tried to bully her in order to roll over on mom. So they were trying to bully her. So we have four different caseworkers and one GAL that all did the same. They all kind of joined in this together. They were all on the same page, so very conspiratorial, and they were all very much on the same page. By the way, one of those people was the leader of DHR in the county in which this occurred, which is Connecticut County. And so what they did was they decided, we want this young lady to roll over on mom, to rat mom out for the abuse and neglect on these kids. And so we're going to compel her and make her do that. And they did that by both a carrot and a stick. And so by that, I mean, they tried to bribe her in a way. So they told her, hey, you can sleep with your boyfriend, so they got her out of the house at this point. And so she's in a foster home. And so they tell her, hey, we'll give you access to a car. We'll get you some college scholarships. We'll let you sleep with your boyfriend. You can have time with him, all kinds of things. But if you don't say these horrible things about your mom, if you don't do that, then we're going to punish you. We're going to classify you as a runaway. We're going to classify you as a level 4 runaway. We're going to classify you as dangerous, which means that when you are put in a psych ward, because we will catch up with you sooner or later and classify you as a runaway, and we will put you in a psych ward. And when we put you in a psych ward, you're going to be classified in such a way that you will be put in with dangerous people that are going to be tough to be around. And so, of course, that's exactly what they did. So teenage girl tells DHR, I'm not going to do this. I'm not going to do this kind of garbage. I'm not going to say this about my mom. And so predictably enough, they do exactly what they said they were going to do. They stick her in a psych ward. They put her in a place that's supposed to be for teenagers to get care and that are runaways and that are difficult and that are engaging in supposedly criminal behavior, although she did nothing criminal. She was not prosecuted for anything at all, ever, but they still classify her as though she were like robbing stores and stuff like that, like crazy stuff. But she did none of that. So they classify her like that. They send her to a place called Laurel Oaks, which by the way is up in Brewton, owned by a company out of Florida. And so Laurel Oaks, of course, makes a huge amount of money from these kinds of kids being sent to them. So anyway, she stays there for a while. Predictably enough, just as they predicted, she gets her butt kicked in there by some of these girls that were tough as they could be. And that's what they purposed it to do. So predictably enough, that happens. She gets her head stomped, so much so that she's bleeding out of her ears. While she's bleeding out of her ear, you've got the head of DHR in that particular county that's literally calling Laurel Oaks and saying, don't believe anything she says about that. She's exaggerating. It's not true. It's not really going on in the way that she says. Don't believe any of that. So they take no action to help her or protect her. They don't send her to a doctor. They don't send her to an emergency room. So she complains enough so that fine, Laurel Oaks says, we've had enough of her. So they transfer her to Hillcrest, which is up in Birmingham. She gets to Hillcrest. She's there within 24 hours. They say something's wrong with this girl. She's bleeding out of her ear. There's stuff going on here that shouldn't be going on. They send her to a hospital. She ends up going to the emergency room. She has an aneurysm and darn near dies.
Oh my God.
So all of that. So I say all that to say that never underestimate how far DHR will go. You think they won't go the extra mile, and look, I know I don't want to turn this into me telling horror stories from all my clients or something like that, but I'm just telling you that
these are stories that need to be heard.
This is they have a willingness to be remarkably evil, and they don't have a whole lot of limits on what their behavior is because not too many people want to rein them in. And so there are very few people that want to rein them in and go after them. I always think that the best way to rein them in is for me to sue them in federal court as many times and as often as I can and repeatedly and make them pay over and over and over again. And the more of these cases that I have, as many cases as I have now in federal court against them, I have so many more in the pipeline now because recently I've kind of had an influx of these cases, and so I've got worse horror stories than that. Let's put it this way: there's molestation going on of kids, and they know about it, but they're not acting on it. They're supposed to be the protectors of kids, theoretically, but they don't. And so I can tell you about one guy who's a molester who's in a foster family now, and he is a male, and it is solely him, and he's got a bunch of young boys, and he only takes boys and won't take girls. And I've got a client whose child was with him and was molested, and DHR knows about it, but they haven't gotten all the kids out. And they know about it. And I know they know about it because I told them. And not only that, there are others that have told them. And not only that, there are previous caseworkers that knew about this as long as a year ago. And they've known about this for a long time. And not only that, if you look in the in the group, on the Facebook group for foster families, everybody knows who he is. Everybody knows him, and everybody knows his name, and everybody knows his deal. And so everybody knows, but nobody acts, which,
Wow.
It's crazy. How can nobody act? How can nobody do anything? Everybody seems to know, but nobody seems to do. And so you got people at DHR. People at DHR actually told my client that if I were you, I would take my kids and I would run. That's what she was advised to do by one DHR caseworker.
Wow.
I mean, she had, they're always chasing caseworkers. So, that was one of the many caseworkers. That's what one of them told her in that situation. But she's not the only one. I got other clients too that have had their kids get molested, and somehow DHR, of course, is never responsible for anything. They have some crazy stuff that they do, and crazy stuff that they allow, and then you have judges, I think, that kind of accept some of the craziness, and and that to me is nuts. And some of those things that judges accept, frankly, are a little beyond the pale, and I wonder what the heck judges are thinking. So I had one judge that removed me from a case because DHR, and she was. So let's put it this way. I had a 17-year-old girl that I represented, that I had filed an appearance on behalf of, and she was in DHR's custody. And so the mom hired me to represent the 17-year-old girl in a criminal matter. And so DHR doesn't want me representing anybody because I'm difficult for DHR. I'm problematic. And so because they know that I wouldn't go along with whatever their plan is, I'm just going to represent my client to do the best I can for my client. In that case, it was a 17-year-old girl who was difficult and obstinate, maybe, but she's mouthy. But she's no threat to anybody. I mean, she's not harmful and she's not violent. She's just mouthy, and she don't want to obey anybody. And I don't really blame her because nobody acts like they care about her. So everybody's telling her what to do, and nobody ever talks to her, nobody ever listens to her, and nobody really cares about her. So you got a bunch of DHR people that are telling her what to do, and they had her sleeping on a sofa at DHR for a couple of days, which was stupid and wrong, and she was mad about that. And I don't blame her for being mad about that. You made me sleep on a couch at DHR's office for a couple of days. I might be a wee bit irritable myself. So all in all, don't blame the girl. And yeah, she was mouthy about all that. So
how dare she?
Yeah, I dare she. And in fact, that very same girl, they called the police on her because she was so mouthy. She was using the F word and telling them to F, off. And so given the circumstances, I really don't blame her. It's a tough circumstance to be in. None of us would like that. And so what do? They call Robertsdale PD. Robertsdale PD, of course, he's all macho cop. He walks up to her. He says, I bet you won't say to me what you said to her. Well, of course, that is like pouring gasoline on a fire for a 17-year-old. It's about the dumbest thing that you could say to a 17-year-old ever. Anybody who's ever had a teenager knows that's like the dumbest possible thing to say. So I'm guessing that particular cop has no kids, I'm guessing. Because it just couldn't be a dumber thing to say. And besides that, it's not the cop's job to go in and stir up a problem. He's supposed to go in and
that's like a training and de-escalation.
Yeah.
Yes.
Come on, this is the dumbest thing you can do. You're supposed to de-escalate, you idiot, not escalate. So what does he do? He challenges her. So what do you think she does? She stands up and says, well, F you. Mm-hmm. And so then he arrests her. And so, by the way, she has a First Amendment right to say that.
Exactly. Yes.
And she was appointed, and she was actually charged criminally for that. And she was represented by an appointed lawyer, and that appointed lawyer pled her guilty to it, which I think was stupid because she has a First Amendment right to say that. And when I say that, by the way, that's not me guessing that or surmising that. There's case law in the state of Alabama that says you have a First Amendment right to say F you to a cop.
Yes,
What
as a
charge?
cop from Louisiana, I can confirm that it's very true. I've had that said to me many
Sure.
times.
Sure.
And you take it.
Sure.
And you don't take them to jail for it.
Exactly. And so not only that, in Alabama, there's the words F you, that there's case law that says you got a right to say that, and there's the finger, which of course we know what that means. So in other words, this is not ambiguous. I'm not just making this up.
Right.
But that's when I say, so it's not that I'm not mad at the appointed lawyer. I just wish he knew more because he pleads her guilty to that. So then after that, then because she's mouthy and she's not obeying DHR, they want to revoke her probation, which is based on that charge. So first of all, I don't think the underlying charge was handled well, and then I'm supposed to represent her. But anyway, what I'm getting to is that DHR doesn't like me representing her, and because she's got custody, what the judge allowed DHR to do was to choose the lawyer. So think about this. DHR is the accuser of the 17-year-old girl, the accuser. And remember, there's a constitutional right to confront your accuser, but the judge is allowing the accuser, which is DHR, to choose the lawyer that she is represented by. So talk about, is completely unconstitutional. It's disgusting.
Yeah.
I mean, it's just so gross and so disgusting. But a judge literally said to me, well, Yancey, they don't want you to represent them. So I'm going to let DHR pick the lawyer. And of course, pointing out the obvious is, judge, really? Judge, you're going to allow DHR to pick the lawyer, even though they're the accuser, and you're allowing the accuser, who she has a right to confront, to pick the lawyer. So do you think the lawyer who is being chosen by DHR is going to confront DHR about whether or not, the accusations are true against the client? I mean, this is poisonously stupid. This is disgusting. And so anybody who cares anything about the Constitution thinks this is horrendous. This is pathetic and disgusting.
You can't even call that nepotism. It's beyond that at that
point.
Oh,
it's not nepotism. It's just a horrendous and disgusting, flaunting violation of her due process rights, because you got a due process right to pick your own lawyer, by the way. And secondly, it's a violation of her right to confront her accuser, who is picking her lawyer. This is disgusting, and the judge is going to allow that. And so, I was literally ordered off the case. Can't represent anybody, I'm told. So
lawsuits against DHR are nothing new. So I was able to look as far back as at least 5 years for the same accusations. How is it that there's been so much litigation pushed at DHR, but there's still just been little to no progress to improve the system?
Well, I don't know that I would say that there's been a lot of litigation pushed toward them, because most people that litigate against DHR don't know how to litigate against DHR, and they don't know how to bring the case, and they don't know how to win them, and they don't bring them often in federal court, and they too often bring them in the wrong place, doing the wrong thing or making the wrong accusations, and so they're often unsuccessful. And so there are certain immunities that apply to anybody that works for the government. And so there are ways of handling those immunities. There are ways of putting together your complaint so that you avoid some of those problems. And often lawyers there are often lawyers in this situation that are well-meaning and they want to do it, but they really don't have the background to understand how you go about litigating. And this is kind of a niche, if you will. So look, first 5 years of my career, I was defending police officers in 1983 actions and defending municipalities for all kinds of stuff in 1983 action. So I started my career in doing 1983 actions. And so bringing a 1983 action is very familiar to me, but it's not that familiar to most people. In other words, it's kind of a unique niche in the law. And so just because you're a good litigator, you can litigate a great car accident case, and you see this wrong that has happened in front of you, you say, man, we ought to sue somebody for that. And he's right, you ought to. But you got to be careful how you do it, because if you do it in the wrong way, then you're going to be kicked out of court, because there are absolute immunities that apply, there are sovereign immunity laws that apply, and there are qualified immunity laws that apply, and you have to be careful in how you litigate it so that you can get through that minefield without getting your case kicked out of court, because that is the primary defense in every single civil rights case that I bring. It's not that there's not a wrong. In other words, they never argue that there's not a wrong. They never argue that at all. What they always argue is that we're immune. And so the only time you get any resolution, like a settlement or any kind of offer of any kind, is after they have filed several motions to dismiss, or anyway, you get a lot of motion practice. So you get a lot of so the first thing you get is what's called a 12B6 motion to dismiss. The second thing you get down the road after you do some discovery is a motion for summary judgment. In other words, they're always trying to kick it out on one of those immunity grounds.
Gotcha.
And stuff like that. And so most of the cases that are filed against DHR are booted out of court because of those issues. But you got to tread through that pretty carefully. And so, like there's a lot to how that guy, it can become very esoteric in how you do that, but kind of the bottom line of the reality is how you draft it matters in avoiding that first motion for 12b6. And then after that, once you go through the discovery and you get to summary judgment, how you couched everything and how you bring this. And so I have a lot of rules before I file a 1983, which is why I say, I mentioned before that I have many more of them in process, because I have a way of vetting them. And by that, I mean, we have case law that says that we can win before we get there. So I don't file any 1983 without knowing that I have case law that says I can win the summary judgment and win the 12b6, because I know both those things are coming. And it's because of how we do things. A lot of times we avoid the 12b6 altogether. The summary judgment's always going to come, but we win those. And for that matter, I haven't had a 1983 kicked out on motion. Anyway, in a long enough period of time that I can't remember the last time it happened. So at least in the last 10 years, it's been more than 10 years since that happened. And part of that's just putting in rules, that you kind of go by, that you develop over time and experience and all that. So I've been doing this for a while. So I know I look like I'm like 25 or 30, but I'm a little bit older than that. So I've been practicing law for 35 years. And so part of that is just, getting to a place and how you do this. It kind of gets back to what you kind of started out asking me, how do you get here? It's because I believe in constitutional rights. I mean, I'm silly enough to really believe in this stuff, which is, it almost sounds kind of romantic at this point, that I believe in that Constitution. I think that all of the constitutional amendments apply to everybody. Mm-hmm. Everybody in the United States, every single person in every situation. I don't care what color you are. I don't care what you do. I don't care who you are, what job you have, or anything else. I think that Constitution, the Constitution of the United States of America, is a great and fantastic document. And I think it is completely underappreciated in a lot of different ways. And frankly, it irritates me. It's one of my many pet peeves, is that you have a lot of people that say stupid things like, well, there are a lot of free countries. And there are a lot of people that, there are a lot of countries that, have some degree of freedom and all that. We're not the only great country and all that. Balderdash. We have a very unique Constitution that does one thing that is extremely unique. And so if you're not offended by me talking about God, what we believe in our Constitution, what our Constitution says, it says this, is that our rights come from God. And the Constitution doesn't do what most constitutions do. Most constitutions define rights and give rights. So most constitutions are kind of like a car dealer. They're dealing out rights. These are all your rights. And all that can be changed, by the way. So the Constitution could be one thing one year, and 5 years later it might be something different. Mm-hmm. And so, but that's not what our Constitution does. Our Constitution recognizes that God is the giver of rights. And what the Constitution does is it limits government. That's the only thing it does. It limits our government from taking those rights from us. So it recognizes, for instance, that we have a right to free speech, or right to religion, and all those kind of basic rights, right to due process. So our Constitution recognizes those rights given by God, and just says, Constitution can't do that. Congress can't pass a law that stops that. No law can be passed that hinders or obstructs your free speech, or, and on it goes through all the different rights. And so, in other words, there's no other country on planet Earth that views the world that way. There's no other country on Earth that views it that way.
And we've gotten lost on that, because I was telling her, with the people I've talked to, people telling us to be careful, I've had to remind people, we are Americans. This is America. We can speak up. Yeah. We can speak our truth. And what weapon can be formed against us when our faith is strong?
Absolutely.
And we've forgotten that as a people, so by and large.
And look, by the way, and if anybody is scared of some sort of retaliation, because you speak up against the government, I have filed 2 suits in the last couple of years. One I have in Tennessee right now with a woman connected to Tennessee's version of DHR, and can't remember what it's called up there. Every state has a different name for these things. So whatever it's called up in Tennessee. So I sued that caseworker in Tennessee for a First Amendment violation. Why? Because my client spoke up, and in retaliation for that, they took away all her foster kids. They took away her ability to get paid for all the foster kids that she had already had. And so they just refused to pay her for it.
Oh.
And so, and then they refused to give her any more kids, and they turned her down for an adoption that was in process, all because she spoke up about one of their caseworkers having done something awful. So in other words, they retaliated against her for her exercising her First Amendment rights. Can't do that.
Right.
That is something that is a civil rights violation. You can't retaliate against me because I exercise my First Amendment rights. And when a government employee does this, see, this is the arrogance of DHR. DHR thinks they can do anything. And so you got to make them pay. And so the great thing about that is not only does it teach that particular idiot a lesson to hold them responsible and accountable for that, but it teaches every idiot in that office.
Yeah.
Oh, hey, maybe we shouldn't try to retaliate against somebody. Maybe we should just respect the right to say whatever. Like you were saying before, you were a state trooper in Louisiana and somebody says F you to you and, and you have to not care.
Right.
I mean, you can't pull out your baton then and whip them,
Exactly.
And you can't, even if it feels insulting or whatever. Sooner or later, I've always thought that the best police officers are the ones that you don't take any of this stuff personally, man. They don't know you. They say dirty words to you or whatever. They don't know you,
right.
And so somebody gets upset with you, but these caseworkers, I mean, some of them are remarkably immature about how they behave in this stuff. You got somebody that's fighting for their kid, and you're offended by them asking for more time with the kid, for instance, in a persistent way. And that's what a lot of these people are doing. They're just saying to somebody, I want to see my kid. Please don't limit me to an hour. Please let me see my kid for 2 hours, 4 hours, something. Let me hang out with my kid for fun. Let me go to I got parents that are begging DHR to let them see their kid like at a baseball game. Let me go to my kid's soccer game. And they're begging DHR for it. DHR, no, can't do it. Even if I sit in the stands and I don't talk to my kid, I can't just see him out there in the field playing soccer. I mean, these are awful human beings at DHR. They're just awful human beings. These are disgusting people. They're just disgusting in every way. And so cry me a river for their whining about anything I have to say about them. I know too much about them to care. They're just awful human beings who do this disgusting stuff. It's sad. It's sad that they take up this behavior and conduct. But it is who they are. They choose to be who they are, but we always choose to be who we are too. And so I make my choices led by my God, and I'm happy to sue them every chance I get. I will never be okay with any kid being abused, hurt, harmed, abused, or neglected. I'm never going to be okay with a parent that has drug or alcohol issues in the presence of a kid. I'm never going to be okay with somebody who's a lunatic, crazy, who's with a kid. But I'm always going to be helping those people that suffer from any of those problems to get beyond it, to get their kid back. And so the people that need to get into rehab, we get them into rehab. The people that are already delivered, then good, you're delivered. I do some things. We got a support group that we send our people to. We got all kinds of things to help them. I got a bunch of books in this place. I give out books to a lot of my clients, free books to them that'll, read this book. If you'll read it, I'll give people a promise. If you're going to read it, I'll give you the book. If you're not going to read it, then I'll give it to somebody else who will read it.
Yeah.
But so not everybody's a reader. Some people need some other kind of therapy or counseling. So we get people into counseling. We get people into therapy. We get people into whatever they need. But the bottom line is, a lot of these people, by the time they get to me, they're very motivated to get their kids back. And they've been very motivated to get rid of whatever the problem was, whether it's drugs or alcohol or get rid of a person in their life that was, scary or something. So.
What would you tell people who think, man, I can't afford private representation. This is way out of the realm of possibility for me. What can you offer them for assistance, and how can they contact you?
Well, I think I would tell anybody that the first thing you need to do is disabuse yourself of the notion that DHR is going to have some reasonable people who are on your side, or they're cheering for you, or they want you to, or they want to help you in some way, or they want to do something to get your kid back. So understand they are not your friends, and they're absolutely your enemy. And I don't care. I've heard judges that will tell people this, it always starts out, adverse and all that. But, after you get over that and you start understanding that they're on your side, then it'll all be better. Boulder Dash. Judge is lying to him when he said that. I immediately told my client when the judge was saying that, I took him out all absolute garbage. Don't believe a thing he says. By the way, that judge used to work for DHR, which is how a lot of these people end up being JU judges, is they used to work for DHR and then they move over to be on the bench, now governing over DHR. In other words, governing the people that used to be their employees. So absolute garbage. So the first thing I would tell that person, that maybe can't afford me is, one, you got to understand DHR is not on your side. Two, do as much research as you can. And we have some free forms, by the way, that we give people, and we're working on getting them on a website so that they can be downloaded. But you can call the office and get some free forms from us. And the free forms will just help you do a couple of things. There are ways of notifying the court in a specific way about all the progress that you're making. So like the person we were talking about before, 2 years clean, stuff like that. So you fill out all these forms. These are all the things they've asked me to do. These are all the things that I've done, and you put that in a form and you file it with the court. Why do you do that? Because DHR does the same thing. And by the way, they will try to strike that. I just had that done by a client, and what did DHR do? They filed a motion with the court to strike it from the record, which, by the way, the judge denied. Garbage. Can't do that. And of course, they had a bunch of stupid objections to it, but nonetheless, judge denied them all. So who cares? But there are other judges that might take up the objection. If anybody's in that situation, give me a call, and I'll tell you all the reasons why the judge can't grant that. So you could use those forms, and more than anything else, I would tell you, can't trust them. You can use those forms. The third thing that I would tell you is go to every single ISP. Whoever they send you to for a psychological evaluation, don't do it. Go get an evaluation by another doctor, and if you don't know who to go to, I can make a recommendation to you. We can. And those are the kind of, I could go on with about 15 of them, but we'll stick to 2 or 3. And so those are the main things that I would say to start out with. So,
would you like to give people your contact information if they have a question for you? Sure.
And so the name is Yancey Burnett, and that's Burnett. And so phone number here at the office is 662-7500, 662-7500, area code's 251. And you can always send me an email. It's my initials and name at yahoo.com. So it's YN Burnett, that's Burnett at yahoo.com. And so, give me a call. I'll be happy to help anybody. And we deal with a lot of people. And so we have a pretty good way of handling these things. And if somebody's out of town or something like that, or at a distance, we can deal with you from a distance. We take care of some of those things too. I mean, we have email, we have Zoom, we meet people by Zoom all the time. That gigantic TV over there is because I get tired of looking at the little tiny camera, on the phone. So we deal with people like that. So bottom line is, we just want to protect people. I hate bullies. We want to push back against bullies, and that's really kind of the primary thing we try to do. So happy to help anybody that that needs it and seeks it.
Thank you so much for what you're doing. There's not a lot of people willing to do this, and it's very admirable. We appreciate the work you're doing.
I appreciate that. Thank you much. And I appreciate you guys for coming, and glad to have you. And so my first time with you guys. So good fun all in all. So good. Yeah. So it's kind of my bailiwick. So as you can tell, I kind of feel something about this. So anyway, I appreciate that. But good time all around. I appreciate that. Thank you much.
Thank you so much.
Very good.